The United States Supreme Court was established by ratification of the Constitution in 1789. Our country's highest federal court, it is the important third partner in the implied checks and balances system of our nation's government. Famous and decisive cases related to discrimination, civil rights, abortion, capital punishment, and the Fourth Amendment have made their way into our vernacular or have become universal reference points. Plessy versus Ferguson, Brown versus the Board of Education, Roe versus Wade, Bush versus Gore. Decisions made by the Supreme Court can illuminate or even migrate our country's compass. RL's own contribution to the court was of William Cushing, an early RL schoolmaster who ascended to the Supreme Court before there was even a United States. As history has taught us, decisions of the Supreme Court are often indicators of our nation's values, culture, and changing demographics. In this polarized and politicized climate, the rooted reliability of this institution is ever more important. The critical role of the Supreme Court has made prominent headlines in recent weeks with the death of the venerated Justice Ruth Bader Ginsburg and the nomination by President Trump of Amy Coney Barrett to fill that now vacant seat. The decisions of the court in upcoming years will have lasting effects on our nation and on each of us. This morning, Derek Ho, class of 1992, David Posen, class of 1998, Mr. David Friedman, father of Daniel and Robbie's son Friedman, will enlighten us on the workings and intricacies of this esteemed institution. All three men spent part of their careers clerking for U.S. Supreme Court justices. Mr. Ho for Justice David Souter, and Mr. Friedman and Mr. Posen both for Justice John Paul Stevens. Clerking for a Supreme Court justice is one of the most coveted, most influential roles in the law profession. Both Mr. Ho and Mr. Friedman also clerked for U.S. Court of Appeals Judge Michael Boudin. Both graduated from Harvard College and Harvard Law. Mr. Posen clerked for Judge Merrick Garland on the U.S. Court of Appeals and graduated from Yale University and Yale Law. Of course, Judge Garland earned our notice by being nominated to the Supreme Court by President Obama in his last year in office. The Republican majority in the Senate did not act on that nomination. Today, Mr. Ho is a partner with the firm Kellogg Hansen in Washington, D.C., specializing in appellate and complex commercial litigation, focusing on class actions and multi-district litigation proceedings, antitrust law, and the False Claims Act. Mr. Ho represented clients at 3 of the U.S. Supreme Court's most significant recent class action decisions, prevailing in all 3. He is also a member of Roxbury Lattin's Board of Trustees. Mr. Friedman is Senior Vice President for Legal and Government Affairs for the Red Sox and Senior Counsel for Fenway Sports Group. He handles a variety of legal matters, including regulatory compliance issues and oversight of litigation. He assists with the club's interactions with Major League Baseball and other major league teams. Mr. Friedman handles legal and business matters for the Red Sox Foundation and works on government affairs matters in conjunction with the club's Fenway Affairs Department. Mr. Posen is Vice Dean for Intellectual Life and the Charles Keller Beekman Professor of Law at Columbia Law School. There he teaches and writes about constitutional law, information law, and nonprofit law, among other topics. In 2019, the American Law Institute named Mr. Posen the recipient of its Early Career Scholars Medal. Mr. Posen's work includes dozens of articles, essays, and book chapters, and his scholarship has been discussed in outlets including the New York Times, the New Yorker, the Washington Post, and NPR. The possibilities inherent in this conversation far outweigh the 45 minutes that we have allocated this morning. But I hope that what we learn will seed conversations throughout the day and into the days ahead. We are grateful to have our guests with us this morning and, of course, their reflections on the Supremes. Please help me welcome Derek Ho, David Posen, and Dave Friedman.
Thank you, Headmaster Brennan. I have the privilege of starting this conversation. It's an honor to be invited to participate in this hall on a very important topic, and a pleasure to be with you, the faculty and the boys. I want to suggest in my short time that the United States Supreme Court is in the midst of a crisis of democratic legitimacy, born of the near complete breakdown in the historically nonpartisan norms for selection of justices, and that the passing of Justice Ginsburg and her potential replacement by President Trump's nominee to the court, Judge Barrett, threatens to fundamentally change the court as an institution. As you said, it's that's a conversation that would take far more than the time allotted, but I want to unpack that a little bit by first level setting on the court's basic structure and functions, second, by briefly describing Justice Ginsburg's life and legacy, and third, by explaining the current confirmation controversy. As I'm sure most everyone knows, the Supreme Court is the highest court in the judicial branch of the federal government, the two others being the legislative branch, the executive branch. Since Marbury against Madison, a case from 1803, the Supreme Court has been the final arbiter of the constitutionality of legislation and executive action through the mechanism of judicial review. In addition to interpreting the US Constitution, it also interprets federal statutes and regulations. So Congress makes the law, the executive branch implements the law through regulations, and the Supreme Court has the final say as to what those laws and regulations means. I'm going to share my screen just to put up a couple of slides. Here you can just see the facade of the Supreme Court building in Washington and the three branches of government. This is the inside of the Supreme Court courtroom. And I just want to mention briefly the process that the Supreme Court uses for making decisions. The court receives voluminous briefs from parties as well as what are called amici curiae, friends of the court. And it then hears oral argument for about an hour per case in this courtroom. The court's justices ask questions to each side's advocates, and then right after argument, usually the same week, the justices vote on how they would decide the case. And then they issue written opinions explaining their reasons for deciding the case that way. And if the justices do not agree, then those who think that the court got it wrong will author what's called a dissenting opinion as to why they think the majority's reasoning was in error. The power to say what the federal Constitution means has had a dramatic effect on American law and society, as Headmaster Brennan alluded to in his opening remarks. In addition to the cases that he mentioned, gay marriage is now a federal constitutional right because of a recent decision called Obergefell against Hodges. Interracial marriage was declared a constitutional right by the Supreme Court in 1967 in a case called Loving against Virginia. The court declared a federal constitutional right to make campaign contributions in a 2009 case called Citizens United, opening the door to super PACs and other wealthy individuals on both sides of the aisle spending millions and millions of dollars on political advertising. And the Supreme Court upheld the Affordable Care Act against a constitutional challenge in 2012 in a case called NFIB against Sebelius. But despite the court's power to change society, its 9 members are not elected. They're nominated by the president and then have to be confirmed by the US Senate. And moreover, the court rules by a simple majority vote. So in each of these cases, all it took to entrench constitutional rights was 5 votes out of 9 justices on the Supreme Court. And advocates in front of the Supreme Court often talk about counting to 5, because all it takes is getting 5 votes out of 9 in order to win your case. If you think about how that compares to the legislative process, where you need a majority of both houses, 435 members of the House and 100 members of the Senate, plus the president to enact a law, it's perhaps no surprise that when an institution that is so small, is so powerful, there are fierce battles over its composition. But as I'll explain, that has not always been the case, despite the fact that that's where we find ourselves today. So let me talk a little bit about Justice Ginsburg, who, as Headmaster Brennan mentioned, passed away on September 18th, just over 2 weeks ago. from complications of cancer. Though barely 5 feet tall, Justice Ginsburg was a legal giant and a pioneer in the modern struggle for gender equality in America. She grew up in Brooklyn, the daughter of Jewish immigrants of modest means. After high school, she went to Cornell, where she met her husband, Marty Ginsburg, to whom she'd be married for 56 years. When she was a student at Harvard Law School in the 1950s, she was one of 9 women in her class of more than 500 students. There's a famous story about how during her first year, the dean of Harvard Law School, Erwin Griswold, invited the 9 women in the class to dinner and interrogated each one about why she felt entitled to take a place of a man in the class. Let's pause on that for a moment. This was 60 years ago, probably in the lifetimes of many of your grandparents. That's how recent the struggle for women's equality has been in this country. Justice Ginsburg then transferred to Columbia Law School so that her husband could work in New York City, and she graduated first in her class. Even still, she got not one single job offer from a New York law firm. And when she was recommended by one of her Harvard Law professors for a clerkship on the United States Supreme Court with Justice Felix Frankfurter, Justice Frankfurter responded that he wasn't ready to hire a woman and asked her professor to recommend a man instead. Again, 60 years ago. Little surprised then that after graduation, Justice Ginsburg decided to become a civil rights lawyer, starting the Women's Rights Project at the American Civil Liberties Union in 1972. She won many notable cases at the Supreme Court, arguing in front of the lectern that you just saw, often emphasizing that sex discrimination adversely affects men as well as women, and always attacking gender stereotypes that were implicit in the law. In a famous case, she helped challenge an Oklahoma statute that prohibited the sale of non-intoxicating 3.2% beer to males under the age of 21, but allowed females over the age of 18 to purchase it. What she argued was that this was discrimination against young men on the basis of the stereotype that they were less responsible than young women. The court agreed, and in doing so, established the principle that legal classifications based on gender face heightened judicial scrutiny. After a decade-long career as a civil rights litigator, Justice Ginsburg was appointed to the DC Circuit, often viewed as the second most important court in the country after the Supreme Court, and then to the US Supreme Court by Bill Clinton in 1993, where she was confirmed by the Senate by a vote of 96-3. And I want you to remember that number, 96-3. There, she was a consistent member of the court's so-called liberal wing, first with Justices John Paul Stevens and David Souter, with whom the 3 of us collectively clerked, and Stephen Breyer. And then after Justice Stevens and Justice Souter retired, joined by Justices Sonia Sotomayor and Elena Kagan. But during her tenure on the court, that liberal wing was often in the minority. And so many of her most memorable opinions were dissents. She would often read those dissents from the bench in cases where she felt especially strongly that the majority opinion was wrong. And she would wear a dissent collar to mark the occasion, all of which made her something of a pop culture icon as a result. And you can, if I can get this to work. This is Justice Ginsburg with her dissent collar and a number of Justice Ginsburg themed paraphernalia that one can easily find on the internet. Posters, mugs, iPhone cases. This is not common for a Supreme Court justice, just to be clear. You will not find a Justice Souter iPhone case. I promise you that. Although the 5-4 conservative majority on the Supreme Court was remarkably stable during her tenure on the court, there was a major change going on beneath the surface. Confirmations to the court were becoming more and more partisan. I asked you to remember that 96-3 number. That was the vote by which she was confirmed to the court. Sorry about this. But if you look at what happened after her confirmation, you can see a steady decline in the bipartisanship of Supreme Court confirmation votes. Justice Ginsburg is right there in the middle at the bottom of the box, 96-3. But then after her, Justice Breyer only garnered 87 votes, Chief Justice Roberts, 78, Justice Alito, 58, Justice Sotomayor, 68, and then Elena Kagan, 63. Then, as Headmaster Brennan alluded to, in February 2016, Justice Antonin Scalia, one of the most reliable members of the court's conservative majority, died while hunting in Texas. President Obama nominated Judge Merrick Garland, who was then a judge on the DC Circuit, to replace him. Judge Garland was expected to vote with the 4 liberal members of the court on many issues, thus giving them 5 votes. Remember, the key on the Supreme Court is counting to 5. But the Republican Senate refused to give Judge Garland a vote, claiming that it was an election year and that the winner of the presidential election that November should pick Justice Scalia's successor. And after President Trump won the election, he nominated Neil Gorsuch, a reliably conservative judge and a former partner of my firm, and he was confirmed to the Justice Scalia's seat, preserving the 5-person conservative majority. This sparked outrage among Democrats and liberals who viewed this as the theft of a Supreme Court seat that should have been President Obama's to fill. The next year, Justice Anthony Kennedy retired. Justice Kennedy was viewed as the court's swing vote, although he voted with the conservatives on most issues. He broke with them and joined the liberal justices in several high-profile cases, including Obergefell. When President Trump replaced Justice Kennedy with Justice Brett Kavanaugh, that was expected to shift the court even further to the right. So when Justice Ginsburg passed away last month, we were, of course, in the heat of an election. Voting had already begun in a number of states. And when President Trump and Senate Majority Leader Mitch McConnell announced that they would proceed to replace her before the election, even though they had refused to hold confirmation hearings for Judge Garland, charges of hypocrisy flew fast and furious. President Trump has now nominated Judge Barrett, Amy Coney Barrett of the U.S. Court of Appeals for the 7th Circuit in Chicago, to replace Justice Ginsburg. Before becoming an appeals court judge, Barrett was a law clerk to Justice Scalia, and then a law professor at Notre Dame. Judge Barrett is a favorite of conservatives, and her recent Rose Garden speech said that Justice Scalia's conservative judicial philosophy was also her philosophy. And if she's confirmed, the conservative majority on the court would grow to 6-3. And because Justice Gorsuch, Justice Kavanaugh, and Judge Barrett are very young, in their late 40s and 50s, that conservative majority could last for decades to come. Realizing that being replaced by a Trump appointee would do severe damage to the cause of equality for which she had fought all her life, Justice Ginsburg dictated the following statement to her granddaughter from her deathbed. "My most fervent wish is that I will not be replaced until a new president is installed." Whether Justice Ginsburg gets her wish remains to be seen, but Senate Republicans are doing everything to prevent it. And whether she is replaced and under what circumstances may well dictate whether the Supreme Court retains its democratic legitimacy, as my colleagues David Friedman and David Posen will elaborate on. Now let me turn the floor over to Dave Friedman, who will talk about the potential implications of Judge Barrett's confirmation for the upcoming election and the law of elections more generally.
Thank you, Derek. You covered a tremendous amount, hundreds of years of Supreme Court history. So I'll talk relatively briefly about the Supreme Court, the election that happens 4 weeks from today, and naked ballots. Sorry, Mr. Brennan, I said we'd keep it clean. I'll explain what naked ballots are in a minute. All right, so President Trump has pushed for very quick confirmation of Judge Barrett to be the next Supreme Court justice, in part because Trump has said, he wants one more judge, his judge on the Supreme Court, for potential cases involving this year's election. Now, is that likely to happen? How could that happen? To understand that question, we have to go back in time 20 years to the year 2000, right before all of you were born, or most of you were born, except for your teachers. We were born before that. So the year 2000 was Democrat Al Gore versus Republican George W. Bush. That election was incredibly close. The Electoral College came down to one state, Florida. Whoever won Florida's electoral votes would be president. Florida had about 6 million votes cast in 2000. George Bush beat Al Gore by 537 votes, about the size of RL's total class of all students. 537 out of 6 million. Think of that. That's like flipping a coin and having the coin land on its edge, not either side. Now, that election was so close that the state of Florida began to recount the votes. They took the ballots and they had people sitting at tables looking at every single ballot. And there was a lot of litigation in court over the recount. So at some stage, the Florida courts, the Supreme Court stepped in, the Florida Supreme Court. Now, this is a really important point. Election law is generally set by the states, not the federal government. There's all kinds of rules that the states set. Things like, what is the design of the ballot? What kind of machines count ballots? What is the deadline for registering to vote? That's different by every state. In Massachusetts, the deadline is October 24th. So if you turn 18 by October 24th, seniors, you can vote in this year's election. But that's a state rule, not a federal rule. What are the rules for voting by mail? When are you allowed to do it? How does that work? What are naked ballots anyway? It sounds really exciting, doesn't it? Well, in Pennsylvania, as in many states, when you vote by mail, you're supposed to take your ballot, you fill it in, Biden, Trump, whatever. You put it inside a secrecy envelope. You sign the secrecy envelope. You put that inside another envelope, you put some stamps on it, and you mail it. If you forget the secrecy envelope, say you vote for whoever, Joe Biden, you fill it out, it's clear as day that you want Biden to win. You put your ballot in an envelope and mail it without the secrecy envelope. Pennsylvania says that's naked and it won't count. So this year there could be 100,000 ballots that people wanted to count rejected because they were naked. So that's an example of a state rule. So what does the Supreme Court have to do with any of this? Derek explained that the US Supreme Court has one job. It decides the meaning of the federal Constitution or US Constitution and federal laws that are passed by Congress. Well, I just told you, election laws are decided by the states, not the federal government. So what does the US Supreme Court have to do with any of this? Well, generally not a whole lot. But in 2000, the Bush campaign sued and said, wait a second, you're doing this big recount and there's no clear rules as to how the different people in different counties are deciding which votes count. And that's a violation of the federal Constitution's Equal Protection Clause, because the federal Constitution does say everyone's guaranteed equal protection under the law. And the US Supreme Court, by a 5-4 margin, said, we agree, you have to have clear rules. We're going to shut this down because this recount basically doesn't follow the law. And the next day after the Supreme Court decision, Al Gore conceded. He said, I disagree with the 5-4 decision. I think it was wrong, but the Supreme Court is the final decider of law. Not me, not Bush. I respect the Supreme Court. I'm going to concede. Fast forward to today. What's going to happen? None of us knows in 4 weeks or 5 or 6 weeks what will happen. This is a very unusual situation because Donald Trump has already said he is not prepared to concede. And he's also said, as I mentioned, that he wants the Supreme Court to decide key issues in the election. Well, what does he mean by that? This year, there's a bunch of battleground states that are going to be very close, probably, we don't know. Some states are very, very unlikely to be close for the Electoral College, Massachusetts being one. Massachusetts is highly unlikely to be contested. But the battleground states, Florida, Michigan, Wisconsin, Pennsylvania, Arizona, those are key battleground states. Each of them have voting procedures and issues that are complicated, that could easily be the subject of debate and fighting and lawsuits. So none of us have a crystal ball. And maybe the election won't be that close. Maybe one candidate will win by a large margin and the Supreme Court won't have to step in. But here are some examples of the types of issues the Supreme Court might end up having to look at for this election and decide whether there's a federal issue, whether it's equal protection or some other federal right. And these are real issues being argued right now. In Wisconsin, when you vote by mail, I told you in Pennsylvania, you can't have naked ballots. Well, in Wisconsin, it's not enough for you to sign your envelope. You need a witness to sign also to say, yes, Mr. Brennan is the one who put that in his envelope. In the age of a pandemic, when we're afraid to be around each other without masks because it's not safe, is that too burdensome? Should the witness certification rule be put aside? That's a live question in Wisconsin. In Pennsylvania, let's say that you vote by mail because you're afraid to show up in person, you don't want to get COVID, so you stay at home with your mask, you vote by mail. If you put your ballot in the mailbox by election day, November 3rd, it's supposed to count as long as it's received by the county 3 days later. The Trump campaign says, no, no, no. It should be received by election day or else it doesn't count. What's the rule? What should be the rule? Another state, Arizona, has the following. If you forget to sign your envelope, as I said, absentee ballot voters have to sign. If you forget to sign, you're given a certain amount of time to fix that. A campaign can call and say, hey, Mr. Posen, you forgot to sign your ballot. You got to go in there and fix that. The question in Arizona is, after election day, should you get a few more days to fix that ballot or not? These are live questions. So what will happen, none of us know. If Ruth Bader Ginsburg had still been on the Supreme Court, as Derek said, you'd have a very closely balanced court. 4 more conservative, 4 more liberal judges, Chief Justice Roberts in the middle, a swing vote, sometimes voting more conservative, sometimes more liberal, would have been very hard to tell. Without Ruth Bader Ginsburg, her replacement could obviously tip the balance of the court. So it's really impossible to know what the court will do. I'll leave you with 2 thoughts about election cases in the Supreme Court and why they are so unusual. First of all, they directly involve politics. But as Derek said, courts aren't supposed to be political. We didn't elect them. So how do judges prevent themselves from having their bias get in the way of their decision? And how do they prevent it from appearing political when they rule one way or the other? The other weird thing about election cases is how fast they move. Derek described the process. There's briefs filed, oral arguments. The whole process of a Supreme Court case takes up to a year, many, many months. Election law cases fly through the system in a matter of a few days at best, because we can't wait. The Constitution says there will be the next president on January 20th. So that rush and pressure and fury creates a very different dynamic, one that can cause all kinds of unusual situations. I personally hope the Supreme Court doesn't have to decide who the president is. It's not a great situation for any of us. I hope any of you who can register to vote do vote so that our votes are all counted. But that is the messy situation that could evolve in the next 4, 5, 6, 7 weeks. I'll kick it over to David to talk about what might happen after the election.
Great, thanks so much, Dave. I'm going to try to put our conversation in a slightly broader comparative and historical frame, and then look to possible reforms to the Supreme Court coming out of these controversies in the future. So the US Supreme Court has been described by scholars as the most extraordinarily powerful court the world has ever known. We have the oldest and most difficult to amend constitution of any country. And whenever the Supreme Court says what the Constitution means, as Derek and Dave both indicated, not only the lower courts, but also all other actors in the system are expected to go along, even when their work is invalidated. Legal scholars call this a system of judicial supremacy over the Constitution's meaning. And it's not the system that many other countries in the world have. in which the legislature and the executive, with various limits, can push back against the court and reject its rulings on certain matters. Moreover, in no other country in the world do the highest court justices enjoy life tenure without a mandatory retirement age. And this has become a more acute issue in our country because prior to 1970, the average tenure of a Supreme Court justice was under 15 years from the beginning of the Republic to 1970. Since then, it's gone over 25 years. So we have less democratic churn happening, justices staying on the bench for longer. At the same time, when justices do retire, we see it happen for strategic reasons so that a congenial president can pick their successor, like Justice Kennedy did with Justice Kavanaugh, or we have the vicissitudes of death, and we have a tragic situation like Justice Ginsburg's passing, leading all of a sudden to a rather arbitrary opening that she certainly didn't want to have happen. So we have a kind of general concern, at least some have, with that system. And it's been made more acute for the Democratic Party in recent years. The last time that a majority of the Supreme Court justices were appointed by a Democratic president was May 1969. So we're over 50 years now straight of a Republican-dominated court. In that 50-plus year window, there have been 5 Democratic presidencies. Democrats have had a majority of the Senate more than half of the time. And in more of the presidential elections than not, Democratic candidates have won a plurality or majority of the national vote, including 6 of the last 7 presidential elections. We now have a situation combined with the hyperpartisanship of the confirmation process in which justices are getting put on the court, the Supreme Court and lower federal courts, where the senators voting for them represent less than half of the nation's population. In Justice Kavanaugh's case, I think it was about 44% of the population through their senators voted to confirm that justice. And of course, the president appointing that justice also did not receive a majority of votes at the national level. So some scholars call this a super minoritarian judge, when you have neither the president nor the senators voting for them, representing more than half of the country. And we have a growing number of those in our judiciary. So we have a small d democratic problem, arguably for the country, and a big D democratic problem for one of our major political parties, which has been losing out on the court. The current court, led by Chief Justice Roberts, has done some surprising things in recent years, but it's also cut back on key democratic and progressive legislative efforts in ways that have concerned people like Justice Ginsburg and Joe Biden. For example, the Roberts Court struck down a key provision of the Voting Rights Act of 1965, which is arguably the most important civil rights measure this country has passed in the modern era. It also cut back on a key provision of the Affordable Care Act, President Obama's signature legislative achievement. And going forward, this is a real concern where the country could be turning in a liberal direction, and we might have a Green New Deal or revamped healthcare legislation or new voting rights legislation, statehood for the District of Columbia or Puerto Rico, measures that many in the Democratic Party at least think are long overdue. And we could see a court that is well to the right of where the country is, invalidating these legislative efforts, teeing up a major conflict between the branches. So in anticipation of that conflict and in concern for what's been happening with the court's composition and voting behaviors in recent years, a lot of scholars and increasingly political actors are talking about reforms to the Supreme Court that could address some of these issues. Let me just give a brief menu or taxonomy of reforms that are being discussed right now, and I'll leave off there. So one category of reforms tries to get at lowering the stakes of these confirmation fights, which, as you heard, have been escalating and getting more bitterly fought in recent years, taking away opportunities for hardball by each side and regularizing the process to some greater extent. The main reform in this bucket would be term limits for the justices. There are a lot of proposals that have been endorsed by scholars on the left and the right for many years now, actually. The most straightforward of which would give the justices 18-year terms, longer than the terms enjoyed by justices in most other countries of the world. And every 2 years, the president would get a new pick. The justices would not actually cease being federal judges at the end of their 18-year terms, which would arguably raise problems under the Constitution, which guarantees federal judges their jobs during good behavior. That's the actual language of the Constitution. It doesn't speak of life tenure in the Constitution. On this proposal, after 18 years, you just no longer remain an active Supreme Court justice. You still may serve on the court in a senior or ancillary capacity, or you may be cycled down to an appellate court. So you remain a federal judge, but you're not an active Supreme Court justice for more than 18 years. And at least arguably, this could be done by ordinary statute and not require constitutional amendment, and would, again, lower the stakes of some of these debates. We wouldn't have some of the contingencies and arbitrariness we've been seeing recently. Another proposal which seems to enjoy a little less support, but would get directly at the issue of the arguable partisan extreme imbalance that has developed on the court, would be some kind of partisan balance requirement by which there would have to be an equal number of justices appointed by either party. This is a little more fanciful at the moment and is less familiar from what's done around the world, but is also starting to get more interest. Okay, I would say if those are the two main reforms being proposed, just in the general good governance, let's not have these blowout fights over every appointment spirit. Other reforms are a little more aggressive. One you may have heard about is court packing. This goes directly to the perceived imbalance in Republicans getting more seats than Democrats think is their due on the court. Court packing is a term that first developed around the FDR administration when he had won landslide majorities. The Democrats had won landslide majorities in the 1930s, and the Supreme Court was resisting their legislative agenda. And FDR proposed adding a new justice for every justice who was 70 years or older on the court, which would have given him 6 at the time, and would have been a mechanism to swing the court in a liberal direction and uphold his agenda. In the end, he was rebuked and was unable to get that court packing scheme passed and lost the battle. On the other hand, arguably he won the war in that the court started to swing in a liberal direction without any new appointments around the same time, perhaps because it was afraid of court packing and general political backlash coming its way. And so he was able to effectuate much of his agenda even without court reform. So there's an ambiguous legacy of that episode, but it does arguably give something of a taint to efforts to pack the court now, given that he was unsuccessful. But Democrats today are talking about whether, in light of Judge Garland not getting a confirmation hearing of any kind with 11 months left in the Obama presidency, and the way Judge Barrett is being rushed through now, it would be appropriate to add 2 or possibly 4 justices of the court, thereby change its ideological balance to be, in their view, more representative. Court packing is a dangerous strategy, as you can imagine, in part because of the obvious tit-for-tat escalation risk. What's to stop Republicans if they regain power in the future from adding 4 more justices and so on? Court packing has led to some of those kinds of downward spirals in other countries where it's been tried. There's a final category of reforms that approaches the problem from a slightly different direction. Instead of just trying to make the selection system more rational or more fair, or trying to make the composition of the court more closely reflect the partisan balance of the country, a final set of strategies would just limit the power of the court. And this can be defended on a number of grounds, including that arguably the US Supreme Court just exercises more power than is appropriate in a democracy of our size. And again, a look around to what the rest of the world does might give support for this view. And the basic strategies there, I don't have time to go into any detail, include stripping the Supreme Court of jurisdiction to resolve certain types of cases, This has been done in the nation's past. The Constitution clearly allows for some amount of this, although the debate's about just how much. So could Democrats try to, for example, prevent the Supreme Court from reviewing the constitutionality of the Green New Deal is on the table now. A little more subtle, perhaps, would be changing the voting rules by which the Supreme Court invalidates federal statutes. The House in the 1800s actually passed a bill at one point that would have required a supermajority rather than a simple majority threshold for the court to strike down a statute. So if you said it has to be 6-3 or 7-2 instead of 5-4 vote to strike down a law, you can imagine we would get fewer laws struck down. And there's a debate here, though, about whether Congress could pass that kind of bill without a constitutional amendment. And finally, I'll just note, some other countries have what's called a legislative override. Perhaps most famously, Canada and Israel have a mechanism whereby after the Supreme Court rules that a statute is unconstitutional, the legislature can come back and with a supermajority vote overrule the court on itself being overruled and get the final word. Now, it actually happens rarely in practice. Usually when the courts in those countries speak, they get some deference, and it's difficult for the legislature to mobilize a supermajority coalition to override the court. But at least in theory, the legislature retains the last word on constitutional meaning, which, depending on your view of the Constitution and democracy, may be another attractive means to get the court, reduce the role of the court in resolving some of our hottest button controversies. So I'll just close by saying, as recently as 5 years ago, certainly 10 years ago, the idea that we would be talking in a hall like this about these options would be fanciful. These were considered off-the-wall, radical ideas. So much has happened in recent years to escalate the confirmation wars and make so many Americans concerned about the future of the court and its legitimacy that we're in a new period in which it's actually plausible that in the coming period, we're going to get one or more of these reforms, whether for good or for ill. It's exciting times at the court at a structural reform level, not just on a case-by-case level. Thanks.
Mr. Posen and Mr. Friedman and Mr. Ho, thank you so much for that. We have just a few minutes here, and we have a question from Daniel Burke, who's a senior. And Daniel's question is, what do you make of the Democrats and Republicans trading stances on the nomination of a Supreme Court justice in the final year of a presidency? If you need me to repeat that, let me know.
Maybe I'll just say quickly, if the suggestion or the question is really, do we think that both parties are acting opportunistically in this regard? I think that's fair. I'll just speak for myself, and I'm in writing saying that I think Senate Republicans' rationale for why it was okay not to move on Judge Garland, but is okay to move in a much shorter time window on Judge Barrett, doesn't hold up to scrutiny, and there is an inconsistency there, which fuels some of the concerns that I was trying to note in my remarks.
I agree with David, and of course, one can argue that there's inconsistency on both sides, because when Judge Garland was nominated, the consistent view of the Democrats was that he should be given a prompt confirmation hearing, and now the shoe is on the other foot for both parties, because the Democrats are now in the position of saying that Justice Ginsburg's replacement should await the election of a new president. Of course, I think it's fair for the Democrats to say that once the precedent had been set in the Garland-Gorsuch process, that precedent ought to apply equally to this situation. But as David said, that sort of is emblematic of the breakdown of the kind of traditional norm of, let's call it, legislative restraint when it comes to the confirmation process.
I think we have time for one more question, perhaps. This question is from George Matthews, who's an alum and a faculty member. And George writes, I always thought there was a difference between having a liberal or conservative jurisprudential philosophy and liberal or conservative political leanings. If there is a difference, has that gap closed over the last few decades?
Maybe I'll just say briefly here that if you want to predict the votes at the Supreme Court on a non-unanimous case, a contentious case, the predictions of constitutional law professors like myself turn out to be much less reliable and worse than just simply looking at the partisan affiliation of the appointing president of the judges. So while I think justices approach their work in good faith, and there certainly is potential daylight between their politics and their jurisprudential views, I'm not suggesting otherwise. It just is the case that increasingly, if you want to predict voting behavior on contested cases at the court, there is a very strong partisan correlation, at least, and that's just an empirical fact.
I'm afraid that we are just at time, and I know that everyone has to get off to their next class. Mr. Brennan, do you have any words to close us out here?
Of course I do. First of all, I want to say thank you to my friends and colleagues for their joining us today and for offering such insight into the often neglected but clearly very important third branch of government. We have heard many, many times over the last several months that elections have consequences. And as we're on the brink of another national election, I just want to remind you, as Mr. Friedman did, that indeed that people vote and the way that they vote is absolutely consequential in determining what our futures will be. I also, as a side note, would simply want to record the fact that the three gentlemen that you see before you, though all were Supreme Court clerks, indeed have very different life paths when it comes to the law. So for those of you who are considering a legal career, you might take these gentlemen as examples of three different ways in which the law can in fact be expressed in their discrete professions. I'm very grateful for that. On Thursday, we'll have a forum on voting, and to Mr. Thompson's class who are preparing to lead us in that particular discussion, I'm grateful, but obviously there'll be some points that were made this morning that will be relevant again on Thursday. In the meantime, I hope everybody has a great day, and I thank Mr. Ho and Mr. Friedman and Mr. Posen for being with us this morning. Thanks very much.